But first, we're going to dive into a fascinating ruling by Oregon's Court of Appeals involving the state's new anti-doxing law and online harassment. That is our big story tonight. Now let's talk about some legal stuff. A recent law in Oregon against doxing just got one of its first really big tests. Doxing is the term used when someone releases your personal information in a public way. It's usually online. It's typically done as a form of punishment or revenge, according to the Merriam-Webster dictionary. Well, earlier this month, the Oregon Supreme Court ruled that when it comes to politicians, the bar for doxing, pretty high. It refused to take a case out of Newberg and let a Court of Appeals ruling stand. The case in general centers around the Newberg School Board. Back in 2021, they passed a ban on Pride and Black Lives Matter flags and anything else they deemed political or controversial. The ban has since been ruled unconstitutional, and two of the board members who voted for it lost to challengers in the last election. But before that, the ban was the subject of much debate and protests and several lawsuits. One of those lawsuits was filed by four members of the former school board who were conservative in their politics. They sued a group of parents, accusing the parents of doxing them. So here's what happened. The parents were members of a private Facebook group created after the political symbols ban passed. Four of the parents posted information about the board members' employers. For example, school board chair Dave Brown worked as a girls' tennis coach in a local school district. The parent posted the athletic director's name and work phone number and email. Board member Trevor DeHart and Brian Shannon each worked for tech companies. Two parents posted their employers' websites and their bosses' phone numbers. Another board member, Renee Powell, had her artwork removed from a local vineyard after a parent in the private Facebook group contacted them. And that is why the four conservative members decided to sue. So let's take a look at the Oregon anti-doxing law that passed back in 2021. It's HB 3047. It prohibits the public release of personal information if the release of that information is for the purpose of harassing or harming the person, and that a reasonable person in that same position would suffer severe emotional distress. Personal information includes things like home address, personal email, personal phone numbers, social security numbers, photos of the kids or their school, family members' contact information, and employer contact information. Okay, so that's the range of it. Initially now, the board members won their lawsuit in the lower court in Yamhill County. They each told the judge that they were really anxious about going out in public in Newberg after the doxing and that they felt unsafe while they were at home. They all said that their relationship with their bosses had changed. Brian Shannon even said he lost his job. The Yamhill County judge wrote that it is problematic for members of the public to use information that could embarrass or motivate a public official to change their position. And the judge wrote that the school board members' private jobs didn't have any bearing on their school board role, writing, "It's unclear why employment or the values of those private entities would be a matter of public interest." But the parents were not satisfied with that, and they appealed that ruling to the State Court of Appeals, arguing that the information was already public. They pointed out that the board members released the information themselves. It was all found on their own campaign websites, their public LinkedIn pages, or quotes they had given to local newspapers or other public places. The parents also argued that the lawsuits violated Oregon's anti-SLAPP law. Now, SLAPP stands for Strategic Lawsuits Against Public Participation. Those are lawsuits meant to scare people off from participating in politics or public affairs. The anti-SLAPP law is meant to protect free speech when it comes to matters that are of important matters to the public. So the State Court of Appeals ruled that the SLAPP law did indeed and in fact protect the parents. It reversed the Yamhill Court's ruling, saying the parents were exercising free speech connected to a public issue or an issue of great public interest. The court also noted that the type of information posted would be less likely to cause severe emotional distress than, for example, posting pictures of the board members' children or home address or the names of the schools that their children attended. They said that the board members were making decisions with the political symbols ban that affected a large number of people. And as elected officials, part of the job is to experience the consequences of those decisions with the public. They quoted the U.S. Supreme Court, writing, "An individual who decides to seek governmental office must accept certain necessary consequences of that involvement in public affairs, including that the individual runs the risk of closer public scrutiny than might otherwise be the case." Basically, It is legal to threaten to socially ostracize or vilify a public official if they do something that you don't like. That's the high bar for doxing politicians we mentioned earlier. The appeals court agreed that since the board members released the information themselves, it was not really considered personal. The court wrote that although they believed that the board members experienced anxiety when they were out in public, that none of them could really prove that they'd actually been harmed. And if you'll remember from that anti-doxing law, it's not enough that the information was just released. They had to also prove they were harmed or harassed because of its release.